So 3 people sent me a link to a blog post that Hank Green did called The Trouble with Trademarks. Now, while my social media law blog has been a little bit dormant lately, I do have a policy that if 3 people send me a story, then I come up with some kind of response to it. But this time I figured, why do a whole blog post? I could just do a video just like Hank Green does. You've probably seen some of Hank's videos, or maybe his brother John Green's videos. They're really good. They're short, they're fast-paced, and they're tightly edited so that you can tell exactly when the speaker is moving from one thought to the next. It's quite clever, really. So this is my first attempt at a video like this, and I want to use it to explain why Hank both gets trademarks and completely misses the point. First, Hank completely gets that trademarks exist to protect a business, and not just in everything that a business could do, but what a business actually does. That's why Hank points out that Burger King can have a trademark in Whopper when it's referring to a hamburger, but Hershey can have Whopper as a trademark when it refers to a candy. Both may have similar nutritional values, but they don't really compete, except they're both in the category of foods I probably shouldn't be eating. Hank's right when he says that trademark is different from other forms of intellectual property when it comes to enforcing it. With copyright and patent, you can choose to be selective, but with trademark, it's firmly in the use it or lose it category. So when Hank writes about the marks that he and his brother decided not to register, they're basically saying that they have opted to lose the protection of trademark law. And that's fine. I understand that decision. It's a very principled decision, and kudos for making it, even though I can understand when it hurts when some big company is making money off of all of your hard work. But where Hank gets it wrong is where he writes, and I quote, "No one really understands how trademarks work." He then went on to write, that's why lawyers spend so much time and make so much money arguing about them in court. Hold on! There's a few things worth clearing up here, because while I admit our legal system has flaws, it's also pretty awesome, and we should be fair when we're criticizing it. Just because an issue like trademarks can be complicated and lawyers disagree about it, doesn't mean that no one understands it. Disagreement does not equal a failure to understand. It's kind of like 2 football teams who disagree about who is better. They may spend a lot of time trying to decide which one is better than the other, but it doesn't mean that the 2 teams don't understand football. What it means is that a system of having a winner and a loser is working. Oh, and the football players are probably making more money than the lawyers, but I'm not sure what that has to do about understanding anything. Because here's the thing, while we have a lot of laws that make it really easy to understand when someone's breaking them or not, we have many more laws that require a little bit more interpretation. So here's an example. If you know the speed limit is 55 miles per hour and you're driving a car 57 miles per hour and you get pulled over and get a ticket, you are breaking the law. Now, the police officer may have been a little bit of a jerk for giving you a ticket for only going 2 miles over, but you broke the law. What would be a bit less clear is if there was a law requiring you to drive safely. Because what does that mean? Safely. Is that the speed? Is that the distance? Does it depend on the weather? Does that impact whether you should be driving with the volume full blast playing Barry Manilow? Even if it's Mandy. The fact that lawyers disagree on the application of a law doesn't mean that no one gets the law. It just means that the system is working. Just like those football players fighting for who is the better team means the system is working. We can disagree about how to interpret some of the rules, but it doesn't mean that no one understands it. I tried to explain this in a tweet to Mr. Green by saying for someone who does a really good job explaining things in videos, it seems odd that you just gave up and said nobody gets it. To his credit, Hank wrote back and said, lawyers keep telling me that lots of people get it, and then they disagree with each other when I talk to them about it. Yes, that's the point. Lawyers disagree with each other. We are hired to be advocates. That's proof that the system is working. There's disagreement, so there can be resolution. Plus, lawyers go through 3 grueling years of school and then endure a multi-day exam just so we can be lawyers. We are specifically trained to see subtle and minute differences from problem to problem. So while it may look like it's a similar situation to people who haven't gone through law school, for lawyers, they look very, very different. That's also why if you ever ask a lawyer a question, they usually start off their answer by saying, it depends. The end result is that you can ask any 5 lawyers the same question, and you'll probably get about 7 different answers. Heck, the Supreme Court has some of the best legal minds in the country sitting on it, and even they don't agree with each other. Sometimes Supreme Court justices will even say, I completely agree with that guy, except he had the wrong reason for saying what he did. Now, in terms of how this all applies to people who generate online content, I'll be the first to admit trademarks can be problematic, both in how you may potentially violate one or in your decision or decision not to enforce a trademark. People understand that, you just may not like the answer. or the lack of a clear answer. Remember when the entire country was unified in dumping ice water over our heads to raise money for a charity? Well, we were all behind that cause until the charity decided to register Ice Bucket Challenge as a trademark. Suddenly, everyone was upset with them, and the charity had to backtrack and cancel their registration. But the bottom line is that our legal system isn't impossible to comprehend. It just has a lot of vagueness built into it. It's built into it on purpose. And yes, trademarks and copyrights are getting harder to enforce and harder to work with as we move into this social media world. That's one of the reasons why I write on the subject and I teach about the subject. Both copyright and trademarks need changes, but it's really hard to imagine what those changes might be, because we can't imagine what the technology is going to be like 15 years from now. So how can we imagine that 15 years ago, Congress could have made some changes to the law that make sense today? Oh, and all of this isn't even touching where Hank wrote about how YouTube doesn't have a good system in place for protecting fair use, because fair use is a huge can of worms. Even the Supreme Court has said that fair use has to be looked at on a case-by-case basis, and that the test isn't easy to apply. All of this would make it really hard for YouTube to just create a system that fairly applies the fair use test. That's a much bigger issue. Let's move on. The last bit of knowledge I'd like to pass on to Hank Green, or to you, is that we don't have simple answers sometimes when it comes to legal topics, but we need to embrace that complexity instead of just pushing it away by saying no one understands this. We get it. It's tough, but contrary to the song, just because the going gets tough shouldn't mean that you should just get going.